Hi, I'm Ken Fossen. One of the more frequently asked questions of school attorneys is it okay for the board to have a closed session to discuss? And then you can fill in the blank. In light of that, let's take a moment today to review the Nebraska Open Meetings Act and the provisions regarding the topics that are appropriate and those that are inappropriate for discussion in closed session. To begin with, we should note that Section 84-1408 provides that every meeting of the public body shall be open to the public except as otherwise provided by the Constitution of Nebraska, federal statutes, and the Open Meetings Act. So let's look for the exceptions to see when it's appropriate to have a closed session. With regard to the Nebraska Constitution, I did not find and am unaware of any exceptions that would arise in the context of a school board meeting. With regard to exceptions created by federal statutes, the statute that is probably most likely to occur would be the Family Educational Rights and Privacy Act, commonly referred to as FERPA. FERPA is a federal law that protects the privacy of student educational records. So, if the situation should arise and the board needs to discuss such information, a closed session would be in order and would be permitted under the Open Meetings Act. With regard to exceptions created by Nebraska law, we'll turn to Section 84-1410, which provides as follows. Any public body may hold a closed session if a closed session is clearly necessary for the protection of the public interest or for the prevention of needless injury to the reputation of an individual, and if such individual has not requested a public meeting. That's worth repeating. Closed sessions are permitted when it is clearly necessary for, number one, the protection of the public interest, and number two, the prevention of needless injury to the reputation of an individual. Those parameters are a bit vague, but fortunately the legislature gave us a little more guidance by providing some specific examples that meet the standards for a closed session. Section 84-1410 continues. Closed sessions may be had for, but shall not be limited to, such reasons as A. Strategy sessions with respect to collective bargaining, real estate purchases, pending litigation or litigation which is imminent as evidenced by communication of a claim or threat of litigation to or by the public body. Discussion regarding deployment of security personnel or devices. Investigative proceedings regarding allegations of criminal misconduct. And D, evaluation of the job performance of a person when necessary to prevent needless injury to the reputation of a person and if such person has not requested a public meeting. After giving some examples of permitted topics for closed sessions, the legislature also included one topic that is specifically prohibited. Nothing in this section shall permit a closed meeting for discussion of the appointment or election of a new member to any public body. So, for example, if a board has a vacancy that it needs to fill by appointment and one of the candidates has a questionable reputation, the board is prohibited from going into closed session to discuss that issue. Okay, so much for the statutes. Let's now take a look at two school-related cases that involve closed sessions. The district won one, and they lost one. Let's start with the Grind versus Board of Education case. The facts in that case were as follows. The Fremont School Board received bids on a boiler project. The low bidder made an error in calculating his bid. In light of that, the low bidder visited with the architect, possibly in hopes of amending his bid. The architect had concerns regarding the low bidder and wanted to visit with the board in closed session. The board agreed and entered into a closed session, citing Section 84-1410 language related to the public interest and preventing the needless injury to the reputation of an individual. After the closed session, the board returned to open session and voted to reject the low bid and award the contract to the second lowest bidder. Well, the Supreme Court ruled against the school district and held that the closed meeting violated the Open Meetings Act. In reaching its decision, the court said this about the board's assertion that it met in closed session to protect the public interest. Here there was a decision to be made. Should the low bid be accepted? And in answer to that question, would have an impact on the pocketbooks and wallets of the public. The question and answer did indeed involve the public interest, but protection of the public interest in this case demanded deliberations in a public meeting rather than resolution in the recesses of a closed session. In addressing the board's assertion that the closed session was clearly necessary for the prevention of needless injury to the reputation of an individual, the court had this to say: "Nothing indicates that the low bid was other than the result of an honest but erroneous computation. We believe the slight discomfort, if any, experienced by a low bidder in the arena of public lettings is far outweighed by the policy favoring openness in the meeting of a public body. Prevention of needless injury to an individual's reputation as a basis for a closed session was not established under the circumstances." The second case we'll look at is McGuinn versus School District number 66. The facts of that case are as follows. McGuinn was a probationary teacher in District 66. That's the West Side Community Schools. The administration recommended non-renewal of her contract. The board held a hearing, and McGuinn requested that the hearing be held in open session. After hearing the evidence in open session, the board entered into a closed session to deliberate. Then it recessed and reconvened at a later date and voted to non-renew McGuinn's contract. McGuinn appealed. She argued, among other things, that the board's deliberation in closed sessions violated the Open Meetings Act. In this case, the court held in favor of the district. Its reasoning involved a provision of the Open Meetings Act that we have not yet discussed. That provision is found in the definition of terms used in the Open Meetings Act. Section 84-1409 states, "For purposes of the Open Meetings Act, unless the context otherwise requires, public body means governing bodies of all political subdivisions of the state of Nebraska." That's language that we'd ordinarily expect. The statute, however, goes on to add, public body does not include entities conducting judicial proceedings. After noting this statutory definition, the court continued, "A board exercises a judicial function if it decides a dispute of adjudicative fact, or if a statute requires it to act in a judicial manner. Adjudicative facts are those ascertained from proof adduced at an evidentiary hearing which relates to a specific party. The hearing in this case and the deliberations which immediately followed pertain solely to the disputed adjudicative facts bearing upon whether the school district had performed the procedural prerequisites and had a sufficient basis for its decision not to renew McGuinn's contract. Accordingly, we conclude that the public meeting laws were inapplicable to such proceedings." So, when a board conducts a teacher termination hearing, it's conducting a judicial proceeding. Since judicial proceedings are not subject to the Open Meetings Act, the board is free to conduct its deliberations in closed session. Having said that, however, please keep in mind that there are other provisions in Nebraska law, in particular sections 79-832 and 79-834, that require the board to take its final action on a teacher's contract in open session. Thanks for watching.